We will hear oral argument this morning in Case 20-843, New York Rifle and Pistol Association versus Bruin. Counselor Downey, Counselor Martinich, what does the Second Amendment protect?
In the eyes of the petitioner, the Second Amendment protects the fundamental right of armed self-defense for our nation, state, and people by militia and individuals. In the Supreme Court case District of Columbia versus Heller of 2008, Supreme Court Justice Scalia wrote that the Second Amendment could be rephrased as, quote, because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, end quote. By this, Scalia meant that while it is not directly stated, the Second Amendment inherently puts significant emphasis on the right to keep and bear arms, specifically for the purposes of maintaining and upholding the security of the free state. The security of the free state, from this point of view, is dependent on this right for people to keep and bear arms, and without this emphasis on the right to keep and bear arms, our ability to ensure the security of the free state would be greatly impaired. Also in Heller, Scalia wrote that, quote, it, being the Second Amendment, protects an individual right to possess a firearm unconnected with service in a militia and to use that arm for traditionally lawful purposes, such as self-defense within the home, end quote. In writing this, Scalia links the individual right to keep and bear arms with the purpose of self-defense and establishes the idea that the possession and usage of arms for the purposes of self-defense falls under the jurisdiction of the Second Amendment and is therefore constitutionally protected.
So why did the framers include the Second Amendment in the Bill of Rights?
Your Honor, the framers included the Second Amendment in the Bill of Rights to stop Congress from disarming state militia and other Americans using the militia clauses in Article 1 of the Constitution. Additionally, an armed citizenry was important for security in the home, in the public square, and to protect against foreign invasion.
What are the limits of the Second Amendment's protections?
Well, Your Honor, the limitations of the Second Amendment's protection are determined by history and tradition on a case-by-case basis. Heller tentatively suggests a list of quote-unquote presumptuously lawful regulations, including bans on the possession of firearms by felons and by the mentally ill, bans on carrying firearms in sensitive places such as schools and government buildings, laws restricting the commercial sale of arms, bans on the concealed carry of firearms, and bans on weapons, quote, not typically possessed by law-abiding citizens for law-abiding purposes, end quote. In this way, the Second Amendment is not an unlimited right with unlimited access, but rather one that is limited to fulfill the interests of public safety while also maintaining and upholding access to individual rights and liberties. Heller was upfront about the role of text, history, and tradition in the Second Amendment's analysis, and about the absence of a role for judicial interest, balancing, or assessment of costs and benefits of gun regulations. Gun bans and gun regulations that are long-standing, or in other words, sufficiently rooted in text, history, and tradition, are consistent with the Second Amendment's individual right. Gun bans and gun regulations that are not long-standing or sufficiently rooted in text, history, and tradition are not consistent with the Second Amendment's individual rights.
What weapons does the term arms include?
Your Honor, the petitioners would like to consider the following definitions to include in the term arms. This would be weapons of war and self-defense, as well as their lineal descendants. In a new and complete law dictionary from 1771, which was written by Timothy Cunningham, arms is defined as anything that a man wears for his defense, or takes into his hands, or useth in wrath to cast at or strike another. In this case, while arms doesn't directly refer to a traditional firearm in the text, a firearm as we know it today would still fall under this definition, meaning that firearms do have legitimate historical standing and were recognized as fundamentally the same tools we refer to today. In the words of Justice Scalia in his opinion for District of Columbia versus Heller case, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, end quote.
What is the difference, if any, between the verbs keep and bear?
Well, Your Honor, there is a pretty big difference between the verbs keep and bear. Specifically in this context, keep is generally referred to holding these weapons at home, whereas bear generally refers to physically carrying these weapons on one's person. There's a pretty obvious distinction here between the two, in that keep generally refers to the existence of these arms in the private sphere, and bear refers to the existence of these arms in the public sphere. Sir William Blackstone was an impactful source of the common law for colonists, which meant that he had a lasting influence on the drafters of the original Constitution and the Bill of Rights. This was seen in his commentaries, which described the absolute rights of individuals as personal security, personal liberty, and possession of private property. From page 129 of the Blackstone commentaries. It was also observed that these absolute rights were protected by the individual's rights to have and use arms for, quote, self-preservation and, quote, defense. As Blackstone saw, individual citizens were therefore entitled to exercise their, quote, natural right of resistance and self-preservation when the sanctions of society and laws are found insufficient to restrain the violence of oppression, end quote. To help clear the meaning of keep, Scalia said in Heller that, quote, petitioners point to militia laws of the founding period that required militia members to keep arms in connection with militia service, and they conclude from this that the phrase keep arms has a militia-related connotation. This is rather like saying that since there are so many statutes that authorized aggregated employers to file complaints with federal agencies, the phrase file complaints has an employment-related connotation. Keep arms was simply a common way of referring to possessing arms for militiamen and everyone else, end quote from DC and Heller of 2008. So with this quote that Scalia provided, essentially he was making the argument that just because people repeatedly refers to keeping arms in this context doesn't mean that it was always consistently related to and connected with the militia, just the same as filing complaints doesn't always mean that it's an employment-related connotation.
What is a militia, and why did the framers refer to it in the Second Amendment?
Well, Your Honor, a militia, as referenced in the Second Amendment, are the state military forces that helped secure our independence and our liberty. The framers specifically referred to a militia in the Second Amendment to ensure that this right would become intertwined with the right to keep and bear arms as a whole, so as to ensure that it would not be taken away from the original intent behind the right itself. Though it is important to note that Justice Scalia, in District of Columbia versus Heller, stated that bear arms was unambiguously used to refer to the carrying of weapons outside of an organized militia. And it was clear that bear arms did not refer only to carrying a weapon in an organized military unit, end quote. Also in Heller, Justice Scalia wrote that the Second Amendment could be rephrased as because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, end quote. By this, Scalia meant that while it is not directly stated, the Second Amendment inherently puts significant emphasis on the right to keep and bear arms, specifically for the purposes of maintaining and upholding the security of the free state. The security of the free state, from this point of view, is dependent on this right for the people to keep and bear arms.
So how should courts determine if a gun control regulation is considered long-standing?
Well, Your Honor, in District of Columbia versus Heller of 2008, it implies since the 1920s in dicta, meaning judicial opinions expressed by the judges on points that do not necessarily arise within the case. However, this principle is not binding because it was merely individual judges expressing their opinions on the case rather than the actual opinions of the case itself. Because of this, we as the petitioners believe that in order to fairly and accurately determine whether or not a gun control regulation is long-standing, we should be examining these gun control regulations through a historical lens. Therefore, we believe since the time of the founding provides a better metric for this analysis. This was evident as even an English right, which was a piece of the foundation of which our Constitution was written. This English right stated that, quote, the right of the whole people, old and young, men, women, and boys, and not militia only, to keep and bear arms of every description, and not such merely as are used by the militia, shall not be infringed, curtailed, or broken in upon in the smallest degree. And all this for the important end to be attained, the rearing up and qualifying a well-regulated militia so vitally necessary to the security of a free state. Our opinion is that any law, state or federal, is repugnant to the Constitution and void, which contravenes this right, originally belonging to our forefathers, trampled underfoot by Charles I and his two wicked sons and successors, reestablished by the Revolution of 1688, conveyed to this land of liberty by the colonists, and finally incorporated conspicuously in our own Magna Carta." End quote.
What is strict scrutiny? Intermediate scrutiny? Rational basis review?
Your Honor, I will go through each strict scrutiny, intermediate scrutiny, and rational basis review, as well as a brief overview at the end. Strict scrutiny is a type of judicial review that courts utilize to decide whether or not a statute is constitutional. When a plaintiff sues the government for discrimination, courts frequently apply the strict scrutiny test. To pass this test, the statute must have been passed to advance a compelling governmental interest, and it must have been made to achieve that purpose. An instance of this being Supreme Court case 22, Korematsu versus United States, though it is well noted that an executive order was used in this process. Intermediate scrutiny is similar to strict scrutiny, though, as illustrated by their names, is a less rigorous test to determine the constitutionality of a policy or law. Intermediate scrutiny is used only when a state or the federal government passes legislation that impacts certain protected groups. In order to pass this test of scrutiny, the challenging law must further an important government interest and must do so in a way that is directly tied to said interest. An example of this being from Supreme Court case 75-628, which was Craig versus Boren, where it was established that intermediate scrutiny was the appropriate level of review for gender-based classification. This came from the argument of Justice William Brennan, who said that the gender-based classification must serve an important government objective and be substantially related to the achievement of such objective. Now, rational basis review holds the least rigor of the three tests and is also similar to intermediate scrutiny in that in order to pass the test, there has to be a legitimate state interest. However, there also must be a rational connection. This is seen in Supreme Court case 17-316 McCulloch versus Maryland, where the case led to the Supreme Court holding that Congress has implied powers found in the ones listed in Article 1, Section 8 of the Constitution, ultimately leading to the establishment of a national bank. Even if the law was not properly adapted to achieve the legitimate goal, it was at the very least reasonably tied to one. So, in a brief summary, rational basis says that reason can establish a relationship between a statute and a legitimate state interest, whereas intermediate scrutiny and strict scrutiny require that there be evidence that such a relationship exists.
So, is there a difference between openly carrying a firearm and concealed carrying a firearm?
Yes, Your Honor. The Supreme Court case Nunn versus Georgia of 1846, in its decision, established the precedent that while carrying a concealed weapon could be constitutionally regulated or even banned, banning the open carry of weapons could not, because doing so would be a direct violation of the rights provided under the Second Amendment. In this sense, Nunn versus Georgia establishes a difference between open carry and concealed carry weapons by creating a distinction in their respective constitutionality in regards to the law.
So, how should the court determine the public safety implications of licenses to carry firearms?
Well, Your Honor, the petitioners urge the court to consider the implications through history and tradition using principles in the District of Columbia versus Heller case, such as that a person may carry a firearm as long as they are not a felon or insane. Thank you.
Thank you, counselors. The case is submitted.